Okay, we're in Article 30. Article 30 is titled Remedies and Pleadings. So before we even get into what we're doing tonight, which is Section 3018 A and B, we're going to go B and then A. Okay, before we even go there, let's just get out of the way what a pleading is. Okay, so in law, pleading is a formal document filed with the court during the early stages of a lawsuit that presents the party's basic position. This is my position on the case, okay? Pleadings can include claims, counterclaims, and specific pleas, such as a plea of guilty or a plea of not guilty, right? Okay? They do not include evidence that the litigant plans to use to prove their case. So this is at the very beginning of the case. You're basically pleading your case, but you're not proving it. You're pleading it, but you're not proving it. Okay? You're going to prove it later. So for example, the plaintiff is filing a complaint that you damaged his car in the middle of the night at 12:15 a.m. Okay? In your pleading, in your answer, you're going to state your case. In other words, you're going to say, no, I did not damage the plaintiff's car. That's not possible because at 12:15, I was at the Copacabana dancing salsa. So there's no way that I could have done that. Now, you're pleading your case, right? But you still have to prove that you were at the Copacabana. So you're not going to do that in the pleading. You're only stating your case. What's going on here? Oh, my screen went out. Hold on. 1 second. So you're only pleading your case. You're not proving your case. Okay? A common pleading in civil cases is the complaint, which is often considered the most important. The complaint outlines the plaintiff's version of events, specifies damages, and highlights the legal and factual basis of the suit. So that's what the complaint is doing and the pleading is doing. Okay, the factual basis of the suit. The complaint must be filed in the correct court and jurisdiction, which may depend on the type of case. For example, divorce cases are often filed in family court, while small claim cases are filed in small claims court, right? In criminal law, the entry of plea, a defendant in response to each change. So here it is. Pleading is one of the first stages of the lawsuit. Okay, in a pleading, the parties formally submit their claims and the defenses against the opposition's claims. So now we know where we're starting. We're in Article 30, Remedies and Pleadings, and we're going to be doing Section 3018, Responsive Pleadings. I'm going to jump to B, and then I'm going to go back to A. Okay, because that's where I started. I was in a quizzer doing a question, and I was like, let me get more into this. So B is affirmative defenses, right? So let's look up affirmative defenses. What is the affirmative defenses? Hold on. My fan is on and it's blowing everything all over the place. Hold on. Dios mío. Hang on. 1 second. Here we go. Okay, an affirmative defense is a legal defense that a defendant can use in a civil lawsuit or criminal charge to avoid or limit liability. Okay? It's an assertion of facts or law that, if proven, would negate the plaintiff's or prosecutor's claims and prevent the defendant from being held liable. Okay, so let's look at that. An affirmative defense. So, you know what? The best way that I can describe this is withholding information. I want you to keep that in the back of your mind, withholding information. It's like when someone, they don't lie, but they don't offer the truth. You understand what I'm saying? That's what this 3018 is all about. It's like they're not being forthcoming. Ay, Dios mío, I keep getting locked out of this sucker. Hold on. All right, I think we're gonna go to the book now. We're gonna go to the book. Okay, so let's read B. We're gonna start B, then we're gonna go back to A. So we know what the affirmative defense is. Okay, so a party shall plead all matters which, if not pleaded, would be likely to take the adverse party by surprise. So let's talk about that. So let's give a really scandalous example and then kind of like a not so scandalous example. So let's say that you're married, right? And your husband is having an affair and he's cheating on you. There would be no way of you knowing that unless you discovered some evidence, right? You're thinking, oh, my hubby's the best. He would never cheat on me. Hubby knows that he cheated, but you don't. So you're not going to ask him and say, hey, have you been cheating on me? Because you don't suspect it and you don't have any proof, right? So he's not going to offer that up. He's not just going to say, oh, yeah, I've been cheating on you, sweetie, right? Then all of a sudden you find an earring on the floor while you're vacuuming and it's not your earring. So now you go to him and you're like, have you been cheating on me? Now all of a sudden he's caught, and he'll probably lie, but let's for the sake of the story in 3018, let's pretend we're in fantasy world. And he's like, well, yeah, I cheated, but you didn't ask, so I wasn't telling. You get what I'm saying? So it's like, you're withholding. Now let's give a less scandalous example. You're in a jewelry store and you see from afar some guy at a counter reach over and steal a gemstone out of the case of jewelry, right? The guy that's selling the jewelry comes back and realizes he's been robbed, right? He doesn't know that from afar you saw this all take place. So he's not going to ask you, but you saw it and you didn't offer that information. You withheld that truth that you witnessed a robbery. Okay? Now all of a sudden, someone else saw the thief and said, hey, yeah, that guy witnessed it. Or they see you on the camera, the store camera, that you saw that. So now they go up to you. Now they're shocked because they had a witness to the robbery, but you never came forth. So that they're shocked. That's shocking, right? You would think somebody would say, hey, like, I saw this guy rob you, whatever. But you chose not to be forthcoming. So that's what they're talking about. The party being surprised. In other words, like, you're the defendant. Because remember, this is affirmative defenses. So this is the defendant in the answer not being forthcoming, right? And then out of nowhere, let's say, you've gone on with the trial and all of a sudden you want to bring in this evidence that, hey, we had this witness, Harry, he saw this gemstone. Wait a minute, you didn't say that in your pleading. You never brought that up. So now the plaintiff is shocked. They're surprised because you weren't forthcoming with your facts and your claims in your response, right? Okay, in your defense. So it's saying, again, a party shall plead all matters, which if not pleaded, in other words, he didn't talk about the robbery and the person seeing it, or the husband didn't admit to the affair, would be likely to take the adverse party, the plaintiff, by surprise. The wife is shocked. The jewelry guy who owns that jewelry that got robbed is shocked because that's a surprise that was there and it was never revealed. Or would raise issues of fact not appearing on the face of a prior pleading, such as, and they're giving examples. Okay, so again, so it's going to be either like an adverse party taking them by surprise, or basically you're not being upfront, you're not forthright and coming forth with the facts in your answer, in your pleading, right? So it's giving you the details. Okay, so then it's going on to say, such as arbitration and award, these are examples, collateral estoppel, culpable conduct claims, in I can't say this word, diminution of damages as set forth in Article 14A, discharge in bankruptcy, facts showing illegality, either by statute or common law. Okay, these are kind of like indisputable things, right? Okay, what is this? Fraud, infancy, or other disability of the party defending, payment, release, res judicata. So in other words, the action has already been decided. There's been a judgment previously, so you can't retry that same action again because it's already been done. So it's like you're not being forthcoming, like there was a decision on that case already, and you're not supposed to be a final judgment, and you're not supposed to be bringing that action to court again because it's already been decided and closed, and it can't be argued a second time because there's already been a final judgment. Res judicata, you're bringing it back in. You can't do that. You see, you like hid that fact. Okay, statute of fraud is when I believe you're supposed to have something in writing. Or statute of limitation. So like the statute of limitation's up, but yet you're bringing it into court and you're not being forthcoming. It's like you're hiding that. So these are all real shady shit. This particular section 3018B is some shady shit. It's like you can't be shady, basically. All right, leave the shade in the shade room. So the application of this subdivision shall not be confined to the instances enumerated. Okay, so let's go to the question in the quizzer that prompted this deep dive into the CPLR code. Is 311. P brought suit against D. Let's say plaintiff brought suit against defendant. Let's just say that. There was a final judgment for defendant on the merits. Plaintiff is now barred. Okay, he can't do it. He's barred from bringing a second suit against defendant on the same cause of action. Okay, by the defense of, so what is going to defend that not being able to bring a second suit against the defendant? I already talked about that. Is it going to be statute of frauds, stare decisis, payment, or res judicata? The answer is res judicata, because remember we talked about that. Res judicata, I'll read you the formal writing of it, but here we go. 3018B CPLR lists res judicata as an affirmative defense, i.e., one which must be raised in the responsive pleading. Res judicata means the matter has been decided in a previous action, and you thought you were going to be shady and try to bring it up again, but you can't because there's already been a final judgment on it and it's barred from being tried again. All right, so we're gonna go back in time because we started with B instead of A. Let's go back to A. Denials. Again, we're still under 3018 CPLR 3018 responsive pleadings. Denials. A party shall deny those statements known or believed by him to be untrue. He shall specify those statements as to the truth of which he lacks knowledge or information sufficient to form a belief, and this shall have the effect of a denial. Okay, so basically, the plaintiff has filed a complaint. In the complaint, he's stating his case, and he's stating what charges he wants to bring against this defendant. Now, the defendant is reading this. He's reading what the plaintiff wrote. Okay. So a party, which is, okay, so he shall specify those statements as to the truth of which he lacks knowledge. So he's basically reading something and he's like, the plaintiff is stating some stuff that he doesn't have any knowledge of, right? Or whatever the plaintiff is stating has like, doesn't have enough information in it in order to form a belief that this is true. So automatically, once he says, he's not going to just come out and say, I'm denying this. He's going to specifically state that he lacks knowledge or information sufficient to even comment on this shit, because it's some bogus shit that he has no knowledge of. There's not enough information to even like make a plea or whatever against the statement or an argument against the statement that the plaintiff is putting forth. So because of him stating that he lacks knowledge or information sufficient to form a belief, it's automatically going to be, this shall have the effect of a denial. So it's an automatic denial from the defendant because he doesn't know what the F the plaintiff is talking. He's like, I don't know what the hell, I have no knowledge of this. I don't know what the hell this is. There's like not enough information. This is like some bogus shit. That's basically what he's saying. And by him saying that he has no knowledge of this, right away it's automatically a denial. He doesn't have to say, I deny this, because he can't even make any statement about it because he has absolutely no knowledge. He doesn't know what the F the plaintiff is talking about. So all other statements of a pleading are deemed admitted. Oh, damn fan. Except where no responsive pleading is permitted. So the defendant is not permitted to make a response. So this is the exception. No responsive pleading is permitted. They are deemed denied or avoided. So that's the other part of this with the denials. Okay, so let's look at the question for 3018A, which is 310. And here it is. If a party in a responsive pleading indicates that he lacks knowledge or information sufficient to form a belief as to the truth of a statement contained in the pleading to which he is responding, the answer is B. It has the effect of a denial as to the truth of the statement. Let's see if there's any details on the back here. I don't know that there is. And here it is, CPLR 318A, which we just read, provides that in a responsive pleading, a response that a party lacks knowledge or information sufficient to form a belief shall have the effect of a denial. And that concludes CPLR 3018.